BingX, a trusted global crypto exchange. Trade spot, futures, or copy top traders easily. Sign up via the link or referral code to get 30 USDT instantly, plus up to 1,500 USDT in bonuses for verification, deposit, and trading.
A significant review in New South Wales, Australia, has recommended that a centuries-old legal principle, known as Dali Incapax, should be formally enshrined in law. This principle asserts that children aged between 10 and 14 are not capable of forming criminal intent or evil. The review, spearheaded by distinguished figures including a former Supreme Court judge and a former senior NSW police officer, proposes a legislative framework to implement this presumption. Currently, while the criminal age of responsibility in NSW stands at 10, the common law presumption of Dali Incapax offers a crucial protection for younger children facing prosecution. It operates on the understanding that these young individuals may not fully comprehend the gravity and wrongfulness of their actions. While prosecutors have the ability to rebut this presumption, a High Court ruling in 2016 clarified that they must convincingly demonstrate that the child understood the serious wrongfulness of their alleged crime. This clarification has had a profound impact. Since its implementation, conviction rates for children in the 10 to 13 age bracket have dramatically declined, prompting calls from political parties, such as the State Nationals, to formalize this protection into law, urging support from both the NSW government and the Liberals. This pivotal review follows alarming findings from the NSW Bureau of Crime Statistics and Research, known as Boxer. Their report revealed a steep drop in the prosecution of 10 to 13-year-olds in court, plummeting from a significant 76% in the 2015-16 period to a mere 16% in 2022-23. The Boxer data also highlights a concerning disproportionate representation of Aboriginal children and those residing in regional and remote areas of NSW within the state's criminal justice system. In response to these statistics and the broader implications for justice, Aboriginal legal groups have advocated for a more substantial change, proposing to raise the criminal age of responsibility to 14 and concurrently remove the Dali Incapax presumption altogether. The review's findings, released on Saturday, were led by Geoffrey Bellew SC, the chairperson of the State Parole Authority and a former Supreme Court judge, alongside Jeffrey Loy, who previously served as the NSW Police Deputy Commissioner. The comprehensive report outlines 7 key recommendations, with the central proposal being the creation of a new legislative framework for Dali Incapax in NSW. This framework aims to solidify the presumption that, unless demonstrably rebutted, a child between the ages of 10 and 14 cannot be considered to have committed an offense. The authors of the report, Bellew and Loy, acknowledge that the current threshold for rebutting the presumption is indeed high. However, they emphasize that this difficulty serves as a vital safeguard, preventing the conviction of children who lack the requisite understanding of their actions. They strongly underscore the significant vulnerability of children in this age group and the profound, lasting impact a criminal conviction can have on their lives. The report also addresses the understandable community concerns surrounding youth crime, but it critically points out that data indicates only a small fraction of children aged 10 to 13 are involved in serious or persistent offending. Therefore, the report urges against conflating this specific issue with broader concerns about youth crime involving older adolescents. Beyond the core recommendation concerning Dali Incapax, the review proposes the introduction of a voluntary pathway within the criminal justice system for young offenders. This pathway would encompass essential elements such as referrals to appropriate services, conduct assessments, and tailored support plans for children facing complex needs. Furthermore, the review suggests that the government should seriously consider implementing court orders that would enable children aged 10 to 13 to access therapeutic treatment when deemed necessary and appropriate. In a statement released on Saturday, NSW Attorney General Michael Daly affirmed that the review's findings indicate the current system is not serving the best interests of either children or the wider community. Daly expressed a desire to avoid situations where children are left without intervention after charges are dismissed or withdrawn, only to re-enter the justice system due to a lack of support in modifying their behavior. The chief executive of the Aboriginal Legal Service, Carly Warner, has publicly welcomed the report's recommendations. Warner articulated a crucial understanding. We know that locking children up not only compounds trauma for that child, it also increases the likelihood that they will reoffend as an adolescent or adult, ultimately increasing future crime. This sentiment was echoed by Timothy Roberts, president of the NSW Council for Civil Liberties, who, at the review's announcement in May, had deemed the review itself completely unnecessary. Roberts questioned the very premise of reviewing a system that, in his view, already upholds fundamental principles of justice. He expressed concern that at a time when society should be debating whether children as young as 10 in primary school years should face criminal charges at all, the government had commissioned a review that could potentially undermine these basic legal protections against unfair prosecutions. Roberts powerfully stated, "What is wrong with the court saying that we need to be sure that children as young as 10 facing criminal charges know that what they are accused of is wrong, and we know this beyond reasonable doubt. Less young children in prison is a good thing." This sentiment encapsulates the core of the debate, a call for robust safeguards to protect the most vulnerable members of society from the long-lasting consequences of the criminal justice system.